Okay, is everyone in the courtroom able to hear me? All right. And is this the case of 2019 CR 6484? Is that the only case, state and defense?
Yes, Judge.
Yes, Your Honor.
All right, then the court is calling 2019 CR 6484, State of Texas versus Kevin Debnab. Can I have the parties announced for the record for the state,
Marcus Sanders.
for the defense?
Bill Simmons.
All right, and are you Kevin Debnab?
Yes, sir.
All right, we're proceeding by video. I'll note for the record, but that both the state and the defense are in the courtroom. I'm handling proceedings from my office so that the courtroom won't be too overcrowded. Is there any objection to us proceeding by video? State?
None.
No, Your Honor.
Defense?
None from defense.
Mr. Debnab, do you have any objections?
No, Your Honor.
All right, then we have been waiting to do this sentencing, and the reasons for us proceeding with sentencing at such a late time from the guilty verdict that was entered on June 9, 2021, is because there has been a new defense attorney appointed. And then we had different parties become ill, and we also had Mr. Debnab become ill. So are both parties ready to proceed? State?
State's ready.
Defense?
Defense is ready, Your Honor.
All right, and state where we left off from our last setting. You were in the middle of providing witnesses. So if you could call your next witness, please.
Yes, Judge. The state calls Gable Santos.
All right, and is Mr. Santos being brought out?
Yes, Judge.
Is Mr. Cox in the courtroom?
Yes, Your Honor.
All right, and Mr. Cox?
Yes, sir.
All right, if you could stand, yes, I see you behind Mr. Moss. All right, Mr. Cox, for the record, could you state your name, please?
Cornelius Cox.
All right, and Mr. Cox, you've been appointed to represent the witness, is that correct?
That's correct, Judge, and I've had an opportunity to converse with him, confer with him.
He doesn't want to testify.
Is there an issue?
Judge, yeah, sorry, the deputy is saying that he won't come out.
Okay, all right, everyone, just give us a moment, please. Okay, we are back on the record. So Mr. Cox, is your client who is a witness, is he going to take the witness stand?
After speaking with him, Judge, I don't believe he is.
All right, then so this is what we're going to do. We're going to reset this case and we are going to reset it for next week. And state, you're now aware that the defendant does not wish to come into the courtroom at all. Mr. Cox, do you know if it's the fact that your client doesn't want to appear in the courtroom and is willing to appear by video, or he does not want to appear at all?
It's my feeling that he doesn't want to appear at all.
And Judge,
That's my feeling.
Yes, state.
if it's just gonna be the same result this weekend, it seems like that's what Mr. Cox is saying, and we'll proceed without calling him as a witness.
I'm sorry, could you repeat that again?
Yes, I said if it's just gonna be the same result next week, and it appears that it will be based on what Mr. Cox is saying, then I said we will just not call him as a witness.
All right. All right, Mr. Cox,
Yes, ma'am.
do you think you need to speak with your client more, or do you believe that this will be the same results if we're to come back next week?
I think he's steadfast, Judge. I don't think he'll change. That's just my opinion. I don't think time has anything to do with it. He's gonna probably feel the same way next week as he feels now.
All right, then state, are you proceeding without him, or you wish the court to have the deputies bring him out?
No, Judge, we'll proceed without him and rest.
All right, then the state has rested. Defense, do you have any witnesses?
No, Your Honor, just argument, Judge.
All right, then the court will hear argument. State, you may proceed.
Will I be excused now, Judge? Or-
Yes, Mr. Cox, thank you for coming.
All right.
Just one moment, everyone. All right, then, state.
Judge, if you would recall from the guilt innocence portion of the trial, Mr. Debnam was charged with shooting a firearm at the victim in our case, who he had burglarized his vehicle. In the course of that, he also committed another offense, which we've proven up in punishment, where he stabbed William Drew Mitchell in the leg during the course of the prior act assault. Additionally, we also proved up the fact that he was in possession of a stolen firearm, that he had committed the offense of burglary of a vehicle. We had a witness testify in punishment. Actually, sorry, defense stipulated to the prior felony judgment, and therefore we've also proven up that he was a felon in possession. During punishment also, we had a few witnesses that we called. Billy DeLeon, who testified that he observed an individual, a black man, stab a Hispanic man in the back. We also had testimony from Detective Jackson, who testified that it was Kevin Debnam who did it, that was arrested that day, and it was Gabriel Santos who was stabbed. There are State's Exhibits 55, which show Gabriel Santos in the hospital. State's Exhibit 49, which show him with a stab wound in his back. State's Exhibit 53, which showed Kevin Debnam, and State's Exhibit 54, which is Kevin Debnam's shoe with blood on it. Also, there was evidence that Mr. Debnam's interview where he admits to stabbing him, but he claimed it was in some sort of self-defense. So identity isn't an issue in this case. The only possible defense would be, or sorry, in the case that we're proving up, the only possible defense would be what self-defense, and based on the witness, Billy DeLeon, it was not. He stabbed him in the back as he was walking away. And so, Judge, we have a defendant who's committed 3 ag assaults as well as possessed a stolen firearm that he wasn't allowed to possess and burglarized vehicles. These were all on different days. He's a danger to not only our victims in the case, but also the community at large. So we're asking that you sentence him to the maximum, which is 20 years.
All right, defense.
Please, court judge. He was convicted of 1 aggravated assault, judge, under extremely suspicious circumstances. As relates to Mr. Mitchell, and again, we're speaking to the punishment phase here. We would like to state for the record, though, that these cases have not been dismissed. It's within the state's power to prosecute those cases if they like, as opposed to waiting to see what happens here. We would also like to state for the record and possible appellate purposes that we believe in effect that my client, Mr. Devman's rights to a jury trial are being infringed upon by this process as a whole, given that the prosecution has chosen to force the defense to defend against these ancillary charges. We're talking about the aggravated assault of Mr. Mitchell. We're talking about this burglary of a vehicle. And we're talking about the possession of a firearm. We have our own strategies that we would pursue in those cases, of which the court had a preview of the last time when Mr. Drew Mitchell was on the stand and was caught giving several contradictory statements, not the least of which to say that he didn't even hear any gunshots fired that night. But we're being forced to conduct a mini trial, which reveals our strategy in terms of how we would proceed if the state were to pursue these charges. And we would like to bring that to the court's attention. Now, as it relates to specifically to Mr. Mitchell, Mr. Mitchell testified that he didn't have his shoes on. Mr. Mitchell testified that the gun was not in my client's hand, but that it was laid out, if the court will recall, it's all in the record. And that as he was reaching to get the gun, that's when he was stabbed by the defendant. Now that was his testimony. It's our contention here that fundamentally Mr. Devlin was walking and was attacked by both of these individuals. When the alleged victim in this other aggravated assault, which is being attempted to be proven here, again, to get around Mr. Devlin's right to compel witnesses, so on and so forth, and to have an actual jury trial, this gentleman just ran out of the house and jumped in on a fight that he saw his brother having. Now, his brother testified to be with the victim in the assault, that he had him in a UFC style chokehold from the back. It was choking him when the other brother came out. And when I asked him whether or not he thought that chokehold was capable of killing someone, he specifically said he didn't care if he killed him. So that shows the seriousness of the chokehold that he had my client, Mr. Devlin, in when his brother comes out and jumps in. The idea of self-defense in the matter of Mr. Drew Mitchell, we think definitely disproves, at least makes it inappropriate for us to be using that in this punishment phase at this time. We would say the same thing about the stolen firearm, and we would say the same thing about the burglary of a vehicle, given that most of this incident didn't even happen in that yard. And so we would ask, my client has been in jail on this case for 604 days. It's actually been closer to 800 if you look at the record. And so we are asking the court to consider the minimum sentence in this case of 2 years. In terms of additional mitigation, my client, not being compelled by counsel, but on his own, has completed several classes and I've shown these to the prosecution. He has a certificate of completion as relates to responsible thinking and healthy personality. He successfully completed 4 to 6 steps 4 through 6 of moral recognition therapy. Step 4 would be raising awareness. Step 5 would be healing damaged relationships. 6 would be helping others. He successfully completed long-term goals and identity training, short-term goals and consistency, commitment to change, classes in self-control, honesty, trust, acceptance, the change companies in the substance abuse program. These are all things that he's done on his own while in jail. He's defining trauma. Trauma covers us in chains. These classes, peer relationships, the change to healthy relationships. And he gets this certificate, Your Honor, which I would try to, I don't know if the court can see this. I've advised several clients to try to get these. He's one of the few that's gotten it by completing all of those steps. He successfully completed all the sessions of breaking the chains of trauma. In speaking to the trauma, he does have combat service ribbons from both Iraq and Afghanistan. Things were not the easiest for him when he did get back from the war. He recognizes that he has a responsibility, though, to himself and to society to not be engaged in violence. And it's our contention here today that all of this was a matter of self-defense. And now in terms of the guilty innocence phase, I wasn't a part of that. In terms of this instant case, we don't appreciate having to reveal our strategy, but if the state did want to proceed, we're definitely going to be proceeding on these other cases on a self-defense.
Counsel,
Yes, Judge.
you mentioned the military service. Do you want to address this? That's in the PSI, where it says that he was convicted while in the military for the wrongful use, possession, and distribution of a controlled substance. And there was a general court martial.
Yes, Your Honor, there was that court martial. It was a dishonorable discharge. I believe that was a federal case. Bad conduct. Sorry, bad conduct, Judge. And he was picking up, but we were simply addressing his combat ribbons, Judge, that he had while there.
All right, thank you. You can continue.
All things considered, Your Honor, when we consider the legality of these proceedings, when we consider the inconsistent testimony that was given, when we consider that we just believe the only thing that the court should be considering at this time is the guilty verdict that was returned in the Mitchell case. We would ask that the court not even give any consideration to these ancillary charges because they most certainly have not been proven. We would ask the court to consider the minimum sentence in this case of 2 years. And if the prosecution wants to move forward with other cases, they can do that, Judge.
All right.
And if the court, I'm sorry, Judge.
No, go ahead. I thought you
If
had.
it pleases the court, would the court be willing to hear from Mr. Devlin at this time?
Oh, are you calling Mr. Debnep as a witness?
He's just asking to make a statement, Judge.
Well, I mean, he can make a statement as a witness and be sworn in. Unless the state has no objection to Mr. Debnep just making a statement.
Judge, we would have an objection.
You would?
Yes.
I didn't, I'm sorry. So you're just saying, if you did state that they can actually. But still, he wouldn't like to, he would not like to make a statement at this time.
I'm sorry, what did you say?
He would not like to make a statement at this time.
All right.
And just, and finally, Judge, I'm sorry, in terms of this issue with Mr. Santos, we don't think it should be lost on the court that he refused to come out here to address that issue. There's definitely some reasons for that. We would also like to bring to the court's attention on that issue of Mr. Santos, that the witness that was referenced by the state, Mr. Billy DeLeon, was asked specifically on cross at our last setting whether or not he recognized the defendant, and he did not.
Okay. All right, state, you have final argument.
Judge, the only other thing that I would point out is in the PSI, and it's Mr. Devlin's statement. For one, he isn't accepting responsibility for his actions, and that shows that he hasn't changed and is likely to commit the same conduct. Additionally, he gives a different version of the facts than he gave at the time of the offense. In the PSI, he says that he had the gun and the gun went off. But as you would remember from his interview, he testified that our victim, Michael Cruz, was the one who had the gun. And so he isn't accepting responsibility. And so again, Judge, we're asking that you sentence him to the maximum.
Okay, just give me a moment, please. All right, this is what the court will do. The court will sentence you to 13 years in the prison. Give you credit for any time served. There's an affirmative finding of deadly weapon. Is there anything else from either side with regards to sentencing?
Nothing from the state.
Not at this time, Your Honor.
Mr. Debnap, I'm showing you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that document with your attorney? Did you understand it?
Yes.
All right, and I see that your signature is on here. Did you sign it?
Yes.
All right, this is not a plea bargain agreement. Therefore, you have a right to appeal. And if there's nothing else from either side, the record will be closed. And state and defense, if you all want to confer on the other charges, I don't know if you all have had a chance to discuss that. And we will stop live stream.